Good evening. Welcome to this week's episode of 60 Minutes. Tonight's segment reflects back on an ugly event in the area of industrial relations, remembered as the Qantas industrial dispute. The dispute began in March 2011 when many Qantas employees took part in industrial action, creating chaos for Qantas and its customers. Initial negotiation attempts failed and the company lost millions, responding with the grounding of all Qantas flights. Even intervention from the Fair Work Australia was required to solve the nationwide. The four major parties involved were Qantas employees, Qantas management, unions, and the federal government. The Qantas employees involved were pilots, ground staff, and subcontracting engineers, who were angered by Qantas's decision to outsource jobs overseas and modern pay rises. The Transport Workers Union, Australian International Pilots Association, and the Australian Licensed Aircraft Engineers Association were all involved to support Qantas employees. The Qantas chief executive, Alan Joyce, and other Qantas management staff were involved because they needed to resolve the conflict as quickly as possible, so that the company wouldn't face any financial losses. Fair Work Australia acted as a mediator throughout the dispute by authorising the initial. In 2010, both AIPAS and ALAEA's enterprise agreements expired. This allowed them to express concerns regarding smaller branches of the company, employing pilots on lower rates, demanding that all contracting engineers were paid the same wages as Qantas staff. On the 15th of March 2011, ALAEA called upon FWA to authorise a ballot inclusive of its members. The action ALAE proposed included to stop working for 1.5 hours in the morning and afternoon and to refuse certain duties. The FWA later authorised secret ballots for AIPA and TWU because they had also called for industrial action. On the 22nd of July, APA commenced its action where in-flight announcements were made promoting job security for passengers. On the 16th of August 2011, Qantas announced 1,000 job cut as the company was set to create a new airline in Asia, resulting in the reduction of Qantas flights internationally. Following this announcement, the TWU proposed that over 3,800 of its members would stop work for 4 hours. Qantas responded to this by accusing the three involved unions of teaming up with regards to action against the company and further allegedly threatening acts against those workers who continued to work during the action. The 29th of October marked a significant day of the dispute as Alan Joyce announced the grounding of all domestic Qantas fleets as a response to more threatened strikes and the claims from unions. This action was permitted through the Transport Legislation Committee's inquiry into the Air Navigation and Civil Aviation Amendment Bill 2011 and the Qantas Sale Amendment Bill 2011, as evidence from Joyce was provided. Following the grounding, FWA intervened, calling for a termination of all industrial action, giving 21 days for parties involved to resolve the dispute. The dispute, however, wasn't resolved in that time frame, but progress was finally achieved on the 19th of December 2011, as Qantas and the ALAEA agreed on a 3% pay rise, job security for existing engineers, and aircraft maintenance. There were issues associated with the dispute that were identified. These included issues relating to employment, differing claims, and tourism. The initial industrial action affected tourism with over 10,000 passengers forced to abandon travel plans because over 100 flights were cancelled, as there was not enough staff available to help. Alan Joyce stated that the initial industrial action had cost the company $70 million and would cost $15 million each week that the action continued. However, the worst part of the issue came with the grounding of Qantas's entire fleet. The 2-day grounding cost the Australian economy industry over $80 million and cost Qantas $20 million a day. Furthermore, the grounding left over 68,000 passengers stranded as 447 flights were cancelled. Bookings had also plummeted with 25% less in sales compared to the same time in the previous year. This was dealt with through legislation when the FWA called for an end to industrial action under Section 424 of the Fair Work Act. Qantas also dealt with the issue by providing all affected customers either transfers or refunds onto other companies' flights. Jetstar added 10 extra services catering for 3,200 passengers and Virgin scheduled an additional 3,000. Another issue faced in the dispute were biased arguments from either side that prevented any fair negotiation from happening. This is demonstrated as AIPA declared that a 2.5% pay increase was required as Qantas pilots were underpaid. However, Qantas later responded, releasing information stating that their pilots received 30% more annually than Virgin pilots, with an income of approximately $355,000 to $400,000. As a result of each opposing side holding their ground, the dispute failed to resolve simply. This issue was addressed under legislation as once the FWA had terminated all industrial action, 21 days was provided so that the dispute could be resolved, which eventually ended in a settlement. The issue regarding jobs and employment heavily shaped the direction of the dispute. Originally, the planned restructure was set to cut 1,000 of the 35,000 positions at Qantas. This was a huge issue, as a key reason for the industrial action that occurred was to promote job security, and this act had clearly been against that. The issue was solved with the final negotiation between Qantas and ALAEA that agreed on job security for engineers. The lawfulness of the actions conducted by the parties involved in the dispute has been questioned under industrial relations law. The Qantas management staff, in particular Alan Joyce's actions to ground all fleets, left customers devastated. Despite the lawfulness of these actions, customers who were financially affected by the flight's cancellations had the right to seek legal action, provided their money was not returned. The engineers, pilots and ground staff involved acted lawfully throughout the protected industrial action process, as they applied through their respective unions to Fair Work Australia for a protected action ballot order. After voting on whether action was needed, all involved unions provided the required three-day notice. However, the lawfulness of the action by unions have been questioned, with claims of harassment and bullying, with many non-striking members facing death threats and subject to intimidation tactics, such as damage to property. As this kind of behaviour is illegal, a police investigation was launched in response, but no substantial evidence was found, so charges weren't laid. FWA conducted itself lawfully, as they followed all procedures relating to authorising the initial action and implemented all required measures. The dispute caused drastic effects for Qantas, as customers' satisfaction, profit and customer numbers all plummeted. The total amount lost during the financial year when the dispute occurred was over $200 million. This was a major financial setback for Qantas, with a significant impact, as the gap between total revenue in the comparison to the previous year at $7.6 billion widened. Customer satisfaction with Qantas went from 87% to 84% as a result, and customer numbers decreased, with many of the passengers affected transferred to other airlines. The brand reputation was also affected, as the media manipulated many members of the public, with an example demonstrated from an impartial member of the public stating, "They have systematically undermined all employees. So much for the iconic Australian airline. You can't treat employees and the public this badly and think the loyalty to an image can be sustained." The only positive Qantas faced was a 6.8% rise in share prices. As all parties had abided by IRA legislation, nothing that occurred could have set a new precedent for future laws, and therefore there would be no need for any reform, with the Director of Reform at the Institute of Public Affairs stating, "Australia's workplace relations are more harmonious than they have historically been." The legally approved resolution behind the dispute was effective, as it let the involved parties have the opportunity to negotiate and determine a fair result. Recommendations to prevent a similar situation occurring in the future include that communication strategies are implemented between disputing parties when renewing certain enterprise agreements, because this would allow all concerns from employees to be addressed by employers. Furthermore, industrial action would not be required. Another recommendation is the construction of a new industrial commission, because this would allow easier circumstances for the government to mediate large disputes and preventing similar effects as those faced by Qantas. Another recommendation is that staff members become more involved with the company, with a democratic environment allowing them to influence decisions, because this would ensure staff could shape how the company operates and therefore meet their employee desires. Thank you for tuning in.